the previous videos, we talked about the determinations of contractor's employment by employer. This happens when the contractor fails to fulfill his obligations. We mentioned about the procedures for determinations of the contractor's employment, as well as the rights and duties of the employer and contractor when the employment of the contractor is determined. There will be a joint inspections between the contractors, architect and quantity surveyor to finalize the extent of the work executed, as well as the materials and goods which has already been delivered to the site. Lastly, we also talk about the final account, which are to be agreed between the employer and the contractor. The process differs slightly between the two possible outcomes, either with dispute or without the dispute. To better visualize the entire process here, let us take a look on the flow chart here. We are talking about the default of the contractor and what are the processes involved related to these determinations of the contractor's employment. This represents the typical timeline. It starts with the date of commencement, and under normal circumstances, the project is supposed to be completed by the date of completions. By the date of commencement, there will be possession of the site by the contractor. Under normal circumstances, when the contractor is not default and the contractor does not bankrupt, the work will be carried out as per normal. By the time of practical completions, the project is handed over back to the employer. This represents the route when everything goes smoothly. Now, during the process of executions of the work, if the contractor defaults or the contractor undergo bankruptcy, this should trigger the determinations of the contractor's employment. The circumstances that the contractor is considered default are listed here. If the contractor files a bankruptcy, the employment of the contractor shall automatically be determined. Now, if the contractor default or file a bankruptcy, this shall trigger the determinations of the contractor's employment by the employer. With that, the employer will need to issue a written notice to the contractor. The relevant notice may also be issued by the architect on behalf of the employer. It is noted that this notice shall not be unreasonably given. For the notice to be valid, the contractor must be proven default. The first notice serves as a warning to the contractor. This will be dependent on the response of the contractors to the written notice. If the contractors are aware of the seriousness of the matter, the contractor chooses to remedy the situations and the contractors no longer default, this shall transform back to the normal process, and the contractor shall carry out the work until to the practical completions, so that smoothly handing over to the employer. Now, if the contractor continue to default, the limits given is within 14 days the written notice given to the contractor. The second written notice may be issued. This will need to be issued within 10 days before the expiry of these 14 days. With that, the employment of the contractors has been determined. Now, within 28 days of the determinations of the contractor's employment, there shall be a call for record, which shall involve the joint inspections with the architect and quantity surveyor. That means the inspections will only occur with the assistance of the contractor, architect and quantity surveyor in order to finalize the extent of the work executed, as well as the materials and goods delivered to the site. Once this joint inspection completed, within 6 months of the completion of the work, the final account should be produced. Now, once the employment of the contractors has been determined, within 14 days, the employer will possess the site, and the contractor will need to return the possessions of the site, transfer the benefit of agreement, remove his belonging, and also pay the costs incurred due to the determinations of the contractor's employment. When come to removing the belongings, there should be written instructions by the architect what are the things to be removed. There are some things such as the construction plant, equipment, the supply of materials and goods, which are to be transferred to the employer for the continual of the project. Normally, the reasonable time shall be given, and if the contractors has not removed the belongings after the stipulated time, the employer may remove and sell the properties without liability. Now we come back to this final account. It happens after the joint inspections. Once the extent of the work executed and the materials and goods delivered to the site has been confirmed, the employer may hire somebody else to proceed with the work. It is before the completion of the work by the new contractor. No payment should be made by the contractors to the contractors who default. This includes those certified but still pending payment. So, after the completion of the work, all the costs incurred shall be concluded in the final account. This final account should be given to the employer and the contractor for them to review and see if any dispute arises. 3 months periods are given for any parties who is not satisfied with the final account to raise a dispute. If nobody raise any dispute within these 3 months, it will be considered without any dispute, and the final account will be conclusive. It is deemed that the final account has been agreed by all the parties. Now we know the final figure from the final account. We will also need to compare with the sum payable to the contractor. There are 2 possibilities here. If the final account is more than the sum which has already been paid to the contractor, that means the contractor has been overpaid. The employer will need to salvage the cost. This can be done either having the contractor to pay to the employer or having the employer to recover from the performance bond. Either way, the relevant cost can be salvaged by the employer. Now, if the final account is less than the sum paid to the contractor, that means the employer still owes monies to the contractor, and therefore the employer will need to pay to the contractor. These are the process if there is no dispute about the final account. In the case that there is dispute about the final account, either the contractors is not satisfied or the employers is not agreeing with the final account, the disputing party will need to write written notice to another party, give a copy to architect and quantity surveyor. The disputing party will need to submit together with the particular to justify the claim. Now it will be up to the architect and the quantity surveyor to finalize the final account. It is either the final account will be amended or it remains the same. This is subjected to the wisdom of the architect and quantity surveyor, as well as the justifications given by the disputing parties. The bottom line is, they will need to be fair and just to both parties. Now, once this final account has been finalized and the dispute has been attempted to resolve internally by the architect and quantity surveyor, the finalized final account will be disclosed to both the employers and the contractor. If now both parties agreed, that means the dispute resolved. And regarding the payments, who is supposed to pay to who shall be worked accordingly. So theoretically, after the dispute has been resolved, you may proceed to this process. However, if still one of the party is not agree with the final account, this may go for the arbitrations. The disputing party will need to file arbitrations within 3 months. By having this as a flowchart, the process of determinations of the employments of the contractors can be easily visualized. It is especially there are so many stages which one can find difficulty in imagining by reading through the text. You will need to know that the only legal reference it will be the statements given in the PAM contract. The information has been simplified into a graphical manner to show the process for the determinations of the employments of the contractor.